Libel occurs when a false and defamatory statement about an identifiable person is published to a third party, causing injury to the subject's reputation. A libelous statement can be the basis of a civil lawsuit brought by the person or group allegedly defamed or, in rare cases, a criminal prosecution. In the libel court case of the New York Times versus Sullivan, the respondent Sullivan, an elected official in Montgomery, Alabama, alleged that he had been libeled by a full-page advertisement published by the New York Times along with four other individuals. Facts leading to the case. The full-page advertisement was written on March 29, 1960, titled "Heed Their Rising Voices." As the world knows by now, thousands of Southern Negro students are engaged in a widespread nonviolent demonstrations and positive affirmations of the right to live in human dignity as guaranteed by the United States Constitution and the Bill of Rights. In their efforts to uphold these guarantees, they are being met with unprecedented wave of terror by those who would deny and negate that document, which the whole world looks upon as setting the pattern for modern freedom. The purpose for the advertisement was for the petitioners to appeal for funds for three purposes: support of the student movement, the struggle for the right to vote, and the legal defense of Dr. Martin Luther King Jr. for perjury indictment pending in Montgomery. Of the 10 paragraphs in the advertisement, only the third and a portion of the sixth were the basis of the respondent's claim, and some of the statements in the advertisement were false about police action allegedly directed against students who participated in the civil rights movement. Respondent Sullivan felt his reputation was damaged by the New York Times publication because he felt the statements in the advertisement referred to him because his duties included supervision of the police. As there is no uniform law for libel, each state decides what the plaintiff in a civil suit must prove and what defenses are available to the media. Elements of a defamation claim are that the plaintiff has committed a serious, notorious, or immoral crime, has an infectious or terrible disease, or is incompetent in his job, trade, or profession. Defamatory statements must intend to be a statement of fact, not an opinion. Also, the statement must be made to a third party. In understanding the differences between private figures versus public figures and negligence versus intent. Because respondent Sullivan was an elected official, he would have had to prove that the defamer acted intentionally or recklessly. In the final judgment of the New York Times Company versus Sullivan in 1964, the Supreme Court ruled judgment for the respondent Sullivan, stating that the advertisement contained factual errors and falsity and malice were presumed. Sullivan was awarded $500,000 for punitive damages. In the United States Supreme Court case of Gertz versus Robert Welch Incorporated of 1974, the petitioner, Elmer Gertz, was a reputable attorney, and the respondent, Robert Welch Incorporated, was a magazine publisher. In this case, Gertz is a private figure. In the published article titled "The American Opinion," Robert Welch Incorporated stated that Gertz had been an official of the Marxist League for Industrial Democracy, originally known as the Intercollegiate Socialist Society, which has advocated the violent seizure of our government. The publication also labeled Gertz a Leninist and a communist fronter. And lastly, Welch published and stated that Gertz was the officer of the National Lawyers Guild, described as a communist organization that probably did more of any outfit to plan a communist attack on Chicago police during the 1968 Democratic Convention. In the published article, The American Opinion, the managing editor did not make any efforts to verify or substantiate the charges against Gertz. Instead, he appended an editorial introduction stating that the author has conducted extensive research in the Richard Nuccio case. The false statements and extensive research in the American Opinion article could have greatly ruined Gertz's credentials, his career, and both his professional and personal relationships. Because Gertz was representing a police officer who shot a teen, he could have been ostracized and even have his life threatened for being accused of being a conformist founder. To avoid the lawsuit, Robert Welch could have checked the facts or supporting documentation for the alleged acts, and being aware of the state laws of defamation, libel, and slander could have helped. Understanding the difference of a public figure and a private figure would have greatly helped the magazine determine what they could write without being sued for libel. In the state of Florida, the elements of defamation are A. The defendant published a false statement, B. About the plaintiff, C. To a third party, and D. The falsity of the statement caused injury to the plaintiff. And E. A plaintiff must also prove that the defendant's fault in publishing the statement amounted to at least negligence. As a communications professional, it's important to understand the significance and impact of using words that could harm one's reputation. These cases remind us to only include factual data and information when interviewing and writing about public and private figures.